Welcome back. If you have just joined us, you're watching News Night on the Arise News channel. And before that break, we took some certain stories, legal stories about development in the judiciary today, including the appeal court overturning a decision by Federal High Court to release funds for Rivers State government. But to help us understand the legal implications of the appeal court ruling is lawyer, rights advocate, and Arise News analyst Frank Tietie. Frank, great to see you tonight.
Thank you, my pleasure.
I mean, so many developments in the courts today, but let's start with the Rivers issue. The appeal court has now ruled that the Federal High Court lacked jurisdiction in this matter. Tell us, what exactly does this mean? Does this one establish a clear precedent on the limits of federal courts in states fund budgetary and governance issues?
Absolutely. First and foremost, the technical knockout for those who think that you can use the Federal High Court to make a pronouncement with matters that touch on a federating unit. We need to understand that the concept of federalism, it doesn't matter because we have 36 states. The concept of federalism is that you have very many countries that are coming together to donate power to a central government to take care of certain things while they maintain certain things independently. So in this case, you cannot, in the face of the constitutional provision that where there are disputes between the units, between the federal unit and the state unit, such kind of disputes can only be entertained by the Supreme Court and not the Federal High Court. So the court did not go essentially into the issues or the propriety of what the governor has done or whether or not monies can be appropriated without a properly constituted House of Assembly. It just dealt with the fundamental issue, and that's what jurisdiction is all about. You have to have a right of entry. You have to have a right the court has to have a right to either hear the court by way of the subject matter or by way of the powers that have been donated to the court by the Constitution. In this case, the Federal High Court lacked it completely, so it was a wild goose chase, and it was turning the law upside down to have approached the Federal High Court in a matter that is so contentious, that that appears to be a subject matter between the federal government exercising the power or an agency of the federal government exercising the power against the funds of a federating unit like a state, in this case Rivers State.
Frank, so basically the appeal court is telling the Federal High Court of Abuja, look, you had no jurisdiction to even sit on this matter in the first place. And this is a topic that we've been talking about when it comes to sort of the recurring misuse of judicial process in Nigeria. How significant do you think this decision is for the principles of federalism? And also this ruling has it drawn a line when it comes to politicization of the judiciary?
No, it hasn't.
It hasn't.
It hasn't in any way. The truth about it is that it's a very dangerous thing to bring very important and constitutional matters that affect the lives of very many people, in this case, the citizens of a state, in the hands of one man, a judge, a single judge sitting. In this country, prior to the colonial times, we had a sort of jury system that dealt with criminal issues, and then there is some wisdom in not allowing a single judge sitting to deal with such matters. That's why the Constitution envisaged that when there are matters that touch on the powers of the federating units, whether the federal government or the state government, it should be the Supreme Court, which is a panel, of either 5 or 7 justices. In this case, we've seen what the wisdom of 3 justices sitting can actually bring out. Now, in this case, you don't understand why the people, and the law often frowns at this concept of collective punishment for the acts of few. So it doesn't matter whatever Governor Fubara has done or what the House of Assembly has not failed to do in being properly constituted. What matters first to the court is that, look, you've got to realize that this is federalism and you need to deal with Rivers State as an independent state first. And it doesn't matter what the president thinks or what any person who has a lot of political weight or influence over the federal government or over the judiciary can do with regards to Rivers State. So it hasn't stopped the politicization. That is almost incurable until we have a fundamental judicial reforms. And I hope it's very, very close.
For clarity's sake, I want to take you back to something you said earlier. You said this was just about the funds, ensuring that the funds go to Rivers State as part of the federating unit.
Yes,
but not on the legality of the State House of Assembly. Was that what you said? Because I'm asking because the initial judgment by the Federal High Court did question the legitimacy of Governor Fuvara to present the appropriation bill to a 4-man State House of Assembly, which has been controversial. So does this ruling by the appeal court not also speak to that issue to say that the governor was right to present to the 4-man, does not lay that to rest?
That is not the Federal High Court does not have the authority. The Federal High Court ought to have sacked itself, ought to have stopped itself from ever inquiring into what is going on in Rivers State when it touches on its powers with regards to, especially when it's being challenged with regards to how it is considered as a federating unit. So when you say that, okay, there is a problem with regards to the constitution of the State House of Assembly, it's a different matter. But when it comes to the fact that a federating unit that is entitled to funds from the federation account, the Federal High Court cannot in any way contemplate making inquiry into it and even making a pronouncement. So with regards to that, because of the foundational issue, the issue of jurisdiction, whatever the court has said and has pronounced becomes a nullity. Until the court that has a proper right to sit over, that has the jurisdiction to sit over the issues, makes a pronouncement with regards to the propriety of the constitution of the Rivers State House Assembly, as it is as we speak today, what the Court of Appeal has pronounced remains law. So the Federal High Court, all that in all totality, all orders, all pronouncement that the Federal High Court made concerning the Rivers imbroglio is a nullity.
But I'd also question that there's some your colleagues, some legal experts, hailed the decision of the Federal High Court in October on October 30th when they made this decision. And in fact, they cited Section 251, giving its jurisdiction, because of the mentions of the federal institutions such as the Central Bank of Nigeria and the parties involved and the matters about the federal allocation account, the FAC accounts.
It's not only about agencies of the federal government alone. And I think I listened to Gochinyere, he made a fine point, that the subject matter also is very important. The subject matter at this time is that with regards to the issues, because they touch on the powers and functions and the rights of federating units, the Federal High Court cannot entertain it. So on that point, on that case, so long as it may have started with issues of funding and holding on funding, or it may have started with the issue of properly constituting the House of Assembly. And you must appreciate this. The truth about it is that the decision of the Federal High Court may not be wrong when it comes to thinking of how appropriate is it that a 4-man member of the House of Assembly would pass a budget. But you see, because there's what we call the entry issue, the threshold issue of jurisdiction. If you fail that issue, no matter how nice, no matter how correct, whatever decision that proceeds from that court, so long as the fundamental issue of jurisdiction has been failed, all such decisions that emanate from there will be a nullity. And that's what has happened. So we are not looking at that propriety, because if you were to step back and to consider what the Federal High Court has decided with regards to the logicality, the propriety of a 4-man House of Assembly making such a decision, you would agree with the Federal High Court. But the Court of Appeal has simply said, look, you cannot entertain such a matter with a subject matter that deals with the powers of a federating unit, the functions of a federating, the existence of a federating unit, and its rights to the allocation from the federal allocation. You cannot in any way entertain such a matter.
Which is entitled to.
In that case, whatever pronouncement you have made becomes a nullity. And it's very important that sometimes the Federal High Court be reminded that it should not be a kind of court that will be seen to be easily swayed by political by political exigencies or by the kind of forces that approach it. Many times in the minds of litigants, they think that the Federal High Court actually exists to do the bidding of the Federal High Court, of the federal government, and that whatever the federal government asks and it goes to the Federal High Court, the Attorney General goes there, somehow it always comes out in favor of the federal government. So this kind of ruling, this kind of judgment of the Court of Appeal comes with a lot of, a breath of fresh air. People can now realize that, yes, sometimes the Federal High Court, no matter how far-reaching it can be, no matter how, I can see that how rascally it may be in certain cases, I would say, the Court of Appeal can always call it to order.
Is this does this mean that our laws are ambiguous? Because we always see High Court orders being upturned. We see that the High Court judges don't know when they have jurisdiction or when they don't have jurisdiction. What is the issue?
We know that our judiciary currently has a problem right now. And I've raised the issue of a single judge sitting. They can easily be swayed by very many factors. It doesn't often always have to be corruption or bribery. As most times they are limited by their experience, before being appointed as judges. They are also limited to the extent of their research. They are limited to the facts and the arguments that are presented to them. Now, let me be honest with you. The reasons the court exists is because there will always be ambiguity with the law. There will always be conflict. There will be many things. And then because of the fact that we are contending, people, especially in political space, contending for political power and for resources, people will always want to interpret the law differently in action and practice. So that's why we have the courts. Unfortunately, and we must realize this, that a single judge sitting oftentimes will do injustice to the law. That's the reason why we have an appellate process in this country.
Let me bring in another part of judicial process or justice administration. We had a story where legal experts are saying for an efficient judicial process, they want a fixed tenure for heads of courts. They say this is to ensure accountability. What are your thoughts on that?
Well, I don't think it's appropriate. The people who head courts, the tradition of the National Judicial Council has been excellent in the sense that make a recommendation of oftentimes one person to the president for the president to appoint in the case of federal courts, and then one person to the governor who also is subject to the approval of the NJC. I think it's appropriate that we stick to this tradition of seniority and not unnecessarily fix. If you fix the tenure, it becomes political, and it's dangerous to politicize the judiciary. It's even more dangerous to allow the judiciary not only to be politicized, but to determine the kind of politics that we play in this country by allowing it to determine those who win elections and those who don't win. And that is where actually the destruction of our judiciary began, where people now know that you can actually buy judgments, you can buy, it doesn't matter what happens in the in the polls during the elections, so long as you are positioned to buy judges, so you have your way, especially by senior lawyers who understand the game. And that's the reason why we've lost so much confidence in the judiciary. But I'm very confident that with all of this opera that is going on, this condemnation of judicial rascality and misactions, I believe and I know that from tradition that the judiciary will call itself to order. These same persons who are congratulating the Court of Appeal today were the ones yesterday who were deprecating the courts, calling judges all sort of names. It is only when it is in their favor politically that they will now say the judiciary is the last hope of the common man. However, there is need for us to do serious judicial reform. Interesting,
and a lot of allegations against the judiciary. We have to go, but very quickly, this is a story that's up. The former governor of Kogi State, Yahaya Bello, has been granted bail. However, there are questions as to will he actually leave the correctional services, or will he remain because of another issue case he has that he's not been able to meet the bail conditions. As a lawyer explained to us quickly, will he be able to leave
bail is a constitutional right.
Yes.
No matter how difficult the conditions of bail, the terms and conditions of bail are, if a detainee cannot meet them, he goes back to the same court. This is our law to say, look, you reduce those bail terms. In fact, it's unconstitutional. It's a violation of a right to deny any person bail in this country. So no matter what's the point making the bail conditions very, very difficult when they cannot be met, when you are mandated by the law to reduce those bail terms so long as so that person will meet those terms. Okay. And if that same court fails, the litigant or the detainee can now approach a higher court for the purpose of reduction. We call it bail reduction application. So I don't think that he will stay there for quite some time. He should apply for a bail reduction.
Thank you so much, Frank Tietie, lawyer, activist, and Arise News analyst. We do appreciate your time.